We will start with the first question. Chapter 4 of the Indian Penal Code deals with A. General explanation, B. Abatement, C. Attempt, D. General exceptions. The correct answer is answer D, that is general exceptions. Chapter 4 of the IPC deals with the general exceptions, contains the section from 76 to 106 of IPC. This question has been asked in many of the state judiciary examinations like MP 2016, Jharkhand 2014, Haryana 2011 and also in Bihar AP 2012. The next question is, what punishment may be awarded to the person whose act is covered under general exceptions of Chapter 4 of the Indian Penal Code? A. No punishment. B. Half of the punishment prescribed for that offence. C. 1/4 of the punishment prescribed for that offence. D. Depends upon the discretion of the court. The correct answer is A, that is no punishment, because Chapter 4 deals with the general exceptions of the Indian Penal Code. That is why they are exempted from any punishment. This question has been asked in the UP 2009 preliminary examination and Haryana 2011 judicial preliminary examination. Next question is, Section 76 and Section 79 of the IPC provide the general exception of A. Mistake of law, B. Mistake of fact, C. Both mistake of law and fact, D. Either mistake of law or of fact. The correct answer is option number B, that is mistake of fact. Section 76 and Section 79 of IPC both relate to mistake of fact and not the law. They are doing the act which are judicially justifiable and excusable acts. Both Section 76 and 79 is a good defense against criminal liability, since a bona fide belief in good faith in existence of fact. This question has been asked in the Haryana 2015 judiciary examination and Bihar 2015 examination. Fourth, A soldier fires on a mob by the order of the superior officer in conformity with the commands of law. Here A has A. committed an offence, B. committed no offence, C. committed murder, D. none of the above. The correct answer is B, that is committed no offence, because this question is based on the illustration of Section 76 of IPC, where A has committed no offence as he was bound by the law and he has to comply with the superior officer's order. So as he is bound by the law, so he is exempted. The next question is, a hangman who hangs the prisoners pursuant to the orders of the court is exempt from criminal liability by virtue of Section 76, B. 78 section, C. Section 77, D. Section 79. The correct answer is Section 78, that is option number B. Here Section 78 of IPC exempts certain person acting in pursuance of the judgment or direction issued under the authority of the court, order of the court, where the act is done in the good faith and that person believes in the legality of the order. That is why here the hangman is exempted from the criminal liability. The next question is, which of the following section of the IPC applies the maxim ignorance of law is no excuse? A. Section 77, B. Section 78, C. Section 79, D. none of the above. The correct answer is Section 79, that is option number C. Ignorance of law is no excuse. It is the legal principle holding that a person who is unaware of a law may not escape liability for violating that law. Just because he is unaware of the content, so he will not be escape from his liability. This question has been asked in the Haryana 2011 UP PCSJ 2015 and Rajasthan APO 2015. Next, under section 80 of IPC, the exemption of accident is available when an act is committed while A. doing a lawful act in lawful manner by lawful means, B. doing a lawful act in any manner by any means, C. doing a lawful act in a lawyer manner by any means, D. all of the above. I hope you must get this answer correct, and the correct answer is option number A, doing a lawful act in a lawful manner by lawful mean. Exactly, सब कुछ lawful है. So the correct this is actually the section 80 provides where nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge, in doing of a lawful act in a lawful manner by lawful means and with proper care and caution. This question has been asked in the UP APO 2015, Haryana 2011 judiciary examination and also in Haryana 2013 preliminary examination. The next question is, A is at work with a hatchet and the head flies off and kills a man who is standing nearby. A is guilty of A. murder, B. culpable homicide not amounting to murder, C. grievous hurt, D. no offence. This is also the example of the previous question. So, I hope you all must get the right answer to it. The correct answer is D. no offence. Further, the next question is, the case of R versus Detley and Stephen is related to the defense of A. insanity, B. intoxication, C. mistake of fact, D. necessity. This is a very famous case. This question has been asked in many examinations like UP AP 2015, Haryana 2011, Rajasthan AP 2015, Bihar in 2012 and also in Haryana 2011. So, the correct answer is D, that is necessity. This is related to the defense of necessity, and it was held that killing an innocent life to save one's own life does not justify murder, even if it is under the extreme necessity of hunger. So, this case is noteworthy, and this is the case of necessity. The next question is, the principle of doli in capex under the Indian Penal Code 1860 is an exception to criminal liability in which of the following section? A. Section 81, B. Section 82, C. Section 84, D. Section 87. The correct answer is option number B, that is Section 82. So, here it means incapable of doing harm. This term has been used to describe a presumption of innocence for children in criminal law in most countries. So, this question has also been asked in the UP 2013 examination, MP 2015, Haryana 2013. The next question is, nothing is an offence under section 82 of the Indian Penal Code which is done by a child, A. under 5 years of age, B. under 6 years of age, C. under 7 years of age, D. under 8 years of age. The correct answer is option number C, that is under 7 years of age. This is dealt with the section 82 of IPC, which provide that nothing is an offence which is done by a child who is under 7 years of age. This question has been asked in many of the examinations like UP SJS 2012, MP 2015, Jharkhand 2012, MP again in 2016. The next question is, section 83 of IPC lays down A. a presumption of fact, B. an inconclusive or rebuttable presumption of law, C. conclusive or irrebuttable presumption of law, D. irrebuttable presumption of fact. The correct answer is, this is an important question, B, that is an inconclusive or rebuttable presumption of law. This is according to section 83 of IPC, where nothing is an offence which is done by a child above 7 years of age and under 12 years of age, who has not attained sufficient maturity of understanding to judge the nature and the consequences of his conduct and the occasion. So, this was asked in the MP 2015, Rajasthan APO in 2013 and UP 2015 judiciary examination. Further, the next question is, which of the following combination is correctly matched? A. Involuntary intoxication, section 86. B. Vasudev versus State of Pepsu, section 87. C. Attempt to commit suicide, section 306. D. Voluntary intoxication, section 83. The correct answer is option number A, that is involuntary intoxication, that is under section 86 of IPC. I would like to tell the correct sections of the B, C and D. B. Vasudev versus State of Pepsu is mentioned under section 86 of IPC. C. Attempt to commit suicide is mentioned under section 309 of IPC. D. Voluntary intoxication is mentioned under section 85 of the IPC. This question has been asked in the UP 2003 examination, UK 2012, UP SGS in 2009 judiciary examination. The last question of this video is, which of the following cases related to the defense on the ground of intoxication? A versus DPP. B. Director of Public Prosecution versus Beard. C. R versus DPP. D. Queen versus Director of Public Prosecution. I hope this case is very famous and you all know this case about it. Still, I would like to tell the correct answer. Answer B, that is Director of Public Prosecution versus Beard, that is DPP versus Beard. Here in this case, a 13-year girl was raped and intoxicated. She was put the hand in her mouth and she was stopped from screaming. So, because of that she died of suffocation. This case is related to the intoxication. I hope you really like this video. My MCQ series will go on like this, section based. I request you all to kindly share this video to your friends, family and everyone. And if there is any query, do ask me in the comment box and do not forget to like and subscribe. Till then, thank you.